Hello, this is Henry Quillian at Taylor English Duma, doing Quillian's Kernels, also known as Litigation Fundamentals with Henry Quillian. There's been a massive Tort Reform Act passed in Georgia this legislative session, which impacts, as far as we can tell, every civil case in one way or another. It's got basically four different aspects to it. One is what we're going to call civil procedure aspects. Another one is called trial procedure and evidence presentation aspects. And then there's a premises liability, entire new cause of action that presumably plants any other causes of action. And finally, something related to evidence on seatbelts. Today, I'll be working with Nils Okeson, who is our able associate who has studied this in many ways. And we're going to basically probe each other's knowledge and probe each other's thoughts on these subject matters. And we'll principally be starting with civil procedure and then work from there through trial procedure. If we get to the premises liability and the seatbelts, that will be somewhat of a miracle. For those out there in the world who may see this video, just know that we are not providing you legal advice. We encourage you to get your own attorney. Not a bad idea to probe your own attorney's knowledge regarding this tort reform law, because the attorney might not have studied it like we have. And but do not try to take this as legal advice. We are not representing you. You need to have representation. So given that, we will start with the civil procedure portion of this. And I would ask Nils to describe what is new with respect to motions of this to dismiss as it relates to the initiation of litigations and how that affects your ongoing trial in the Georgia state and superior courts.
Well, and before anything else, comments, questions, hecklings are absolutely welcome, especially given the fact that this is clearly, this whole act is rife with holes and rife with situations that they clearly did not account for when they wrote it. But first things first, the motion to dismiss change. Now, typically when somebody files the complaint, the presumption is upon service as counsel for defendant, you answer within 30 days. And if you wanted to file a motion to dismiss because you had any basis for such, you would have to file that motion in tandem with the answer, or vice versa, depending on which you prioritized. Now, this new law essentially allows it. Section 2 of this new act, Senate Bill 68, says that you may file a motion to dismiss in lieu of an answer. And to do so will immediately stay discovery for a period of, well, it's actually not entirely clear about the period, but as procedurally it would go, a plaintiff would presumably file a motion in opposition to the motion to dismiss. And then after 90 days, upon motion by any party, and for good cause showing, the court may undo the discovery stay.
But one thing that's strange about that, Nils, is it says 90 days after the briefing of the motion to dismiss. So what does that mean? There's a filing of an answer within, a motion to dismiss within 30 days of the service of the complaint.
Right.
And then how long does the plaintiff have to respond to that?
30 days.
Unless it's extended by some stipulation. And then how long does the court have to decide after that?
Well, 90 days, presuming that good cause is shown and the plaintiff or any party that feels that the discovery stay should be lifted makes a motion.
Okay, so how many days out are we from the service of the complaint at this time?
150.
And then if nothing happens, if the plaintiff does nothing, then where does the court case go?
It just stays there. It just stays there for the court to rule on motion to dismiss, which courts are known to be really, really prompt about. They're not actually about ruling on.
Now, the same statute does leave open the opportunity for the court not to rule on the motion to dismiss until trial. But how would that work?
Well, assuming the court does that, then there's 15 days for the defendant to file an answer. But also that says, and the wording of that is notice from the court. So assuming that the court actually takes prompt action, either by denying the motion to dismiss or saying that they're putting off the motion to dismiss until such time at trial, the defense attorney must then be very prompt in filing that answer within 15 days, because the wording is 15 days of notice from the court.
So that means if you're there arguing orally, your motion to dismiss and you're the defense attorney and the judge says, not buying it, I'm gonna deny it. You have 15 days from that day in court or until 15 days after the court actually enters an order denying.
I mean, it's not clear, but I would do it 15 days from that day in court.
Yeah, because the words are notice of the court's action. Eddie?
Well, if the court has, if it's analogous to other situations, if the court has announced a clear intention in ruling, then it doesn't need to be written. The parties are on notice. So I would believe that would be the operative date. And I certainly wouldn't wait for a written notice from the court.
Okay, because what happens if you don't file an answer, Eddie?
I don't know. It's never happened. Arguably, you could be in default.
Okay, and what would you do to learn whether you filing an answer is necessary within 15 days? You would read the rules, and these are now the rules. This new statute is now the rules, right? So now, I did note that the court says, I mean, the statute says that if the court does not rule within 90 days, then one of the things that can be preserved by the plaintiff is seeking a writ of mandamus. What is that? Basically, that's asking the appellate court to force the lower court to rule, right? How often does that work? I would say it's very rare, but it has happened. So the general idea would be to say that for the plaintiff to say, this has gone on long enough. You've had 150 days. There's no ruling. We need to get on with this case. We make a motion. But how long does the court have to rule on that motion? Who knows? So basically,
With the mandamus, is that under this, is that a automatic appeal of the court appeals or nature of interlocutory?
I literally have no idea.
I mean, it doesn't say.
I would have to go
No
figure that
decision on
out.
the merits, so
I'd have to read it.
presumably it would be because it's not a decision on the merits. There has been no decision.
Okay, so what can the defendant do if they want to get on with discovery, even if there is a motion to dismiss?
File an answer.
Okay, so if there are multiple defendants and one of them, they all file motions to dismiss and one of them wants to get on with discovery, the defendant simply files the answer and then who can do the discovery?
So is that, yeah, if one of four defendants answers and effectively kickstarts the discovery process, does that mean that the defendants who are still waiting in the wings with their motions to dismiss that have not been ruled on must participate in discovery? And alternatively, let's say that the 6-month period upon the end of the answer is the discovery period for that defendant. How does that impact the discovery when it should hopefully commence at a later date for the other defendants? It's not in there, but we're not asking these questions as if to try to infer that or say that, hold you guys in waiting that, oh, we're going to tell you, nope, that's it. It's completely left in the open as to that.
And then are the defendants that have not yet answered, are they non-parties or are they parties?
I mean, they're parties,
For
but
purposes of discovery.
that's the problem. It doesn't say.
So,
Having said that, I mean, it would probably be in the best interest to, I mean, this is just like a hypothetical scenario, but what if, say, there was like a special appearance answer, there was a special appearance response to discovery or something like that. I mean, that's something that's yet to be explored, but that's just one of the can of worms.
there is in section 4, which would be, what was this, be 12, OCGA 911, 12J4. The opportunity for the court, for the parties to seek discovery on things such as personal jurisdiction, and otherwise to establish jurisdiction of the court and things like that. But it must all be done by motion to the court.
Which is currently still not ruling on these motions to dismiss.
Right.
But wouldn't there be a good faith if you just do it as a delay tactic as a defendant to gain 90 days or whatever it may be till the court rules, there's still a good faith obligation on you to assert that motion, Smith. So you need to still have plausible grounds, I assume. Does it say anything about that or does we just assume that's implicit?
No, I think that's implicit. I'll also mention we have had litigation fundamentals on serving discovery with the complaint. this stymies the ability of the plaintiff to actually get answers to the discovery under those circumstances. But eventually, I suppose you could say, well, I just served all this discovery. That discovery is going to be applicable whenever the clock starts ticking on it. But it certainly does slow down the process. Also be aware in the statute, there are 3 words that are used seemingly possibly interchangeably, but they're not all the same thing. There is notice of the court action, notice of the court's order, and then, which is theoretically notice, like Eddie was saying. And then there is service of the answer and filing of the motion to dismiss. And so it seems like, for instance, the rule does not say the defendant has to file an answer. It says it has to serve an answer in response to a complaint. So some thought should be given to whether you have to file everything that must be served, probably, or whether you have to, if you file something, you certainly have to serve it. So I don't know why the legislature has decided to use the difference between service and filing, but just note those differences. Okay. Second issue on the civil procedure side is
Voluntary dismissals. The whole new rule about voluntary dismissals that pretty much completely undermines all of these courthouse dismissal without prejudices in order because of a bad jury before you've sworn in your first witness, a bad judge, or rather just an inability to get settlement, or perhaps not just being prepared for trial. All of the above. The new rule.
you used to be able to file it and then bring it back and
Right.
within 6 months.
Right.
Okay.
Or the termination or the conclusion of the statute of limitations, whichever one is longer. But the fact of the matter is, this now rule says that it must, if you were to do that, you have a one-time opportunity. That's still the same, but it must be within 60 days of the answer being filed. 60 days. So that completely negates that previous practice of simply hitting the restart button on the lawsuit. So if you want to voluntarily dismiss it for whatever reason you have 60 days from the service of defendant's answer.
Notice it doesn't say filing of the answer, it says service of the answer.
And something else I think is worth noting is there are only 2 of the 8 or so sections that dramatically change the law here that are not retroactive. The one we just talked about, as well as this one, are both retroactive. So cases where presumably cases where it's been more than 60 days but are actively ongoing, the plaintiffs have all effectively lost their ability to have their one-time voluntary dismissal.
Yes, and in fact, in one tort case I'm aware of, counsel specifically discussed with the client, do we have any reason why we want to dismiss this case before the Tort Reform Act goes into effect? Because once it went into effect, that opportunity was lost. Now, with respect to dismissal, under Rule 911-41, there is the question of how do you go about at the end of a case just dismissing the case, or let's say you settle it. And the rule is basically the same, except that in order to get a multiple party case dismissed, you have to have an order of the court after the initial dismissal time is extended, right, or expired.
Another can of worms that one opens up is, again, something that was very clearly not taken into account with some of these multi-defendant lawsuits. Hypothetically, let's say there's 3 defendants and 2 have been served and 2 have filed answers, starting that 60-day clock, but the other one's still sitting in limbo. Does the plaintiff now retain the opportunity to dismiss only as to that defendant? But what if that's an essential defendant? It's completely silent as to that hypothetical scenario. So that's probably going to keep the appellate court's hands full for the next 10 years. As with several other things of this.
So the answer is you're going to have to read the rules and then figure it out. Start reading a lot of case law as it eventually percolates up. Now, the other thing we have designated under civil procedure, could be trial procedure, is in section 4 under 9 OCGA 91516. And it's in reaction to a case, which is what, Farmer versus Joyner or something like that, or Joyner versus Farmer, where Junior versus Graham, I'm sorry. In Junior versus Graham, the Supreme Court of Georgia held that you could recover under OCGA 13611 and under OCGA 91168, which meant that the plaintiff double recovered on attorney's fees. Whereas apparently the legislature didn't like that. And so they've entered a provision in section 4 that says you can't recover twice, and you have to designate which statute you intend to recover your attorney's fees under. And I don't know exactly how you do that, because if you designate 13611 and the jury issues a verdict, then are you waiving your 91168 claim entirely? Which is, they may or may not thought about that, or you just can't recover more than the total amount of attorney's fees you have, because they theoretically your 13611 would be from the start of the litigation, and 91168 would be your start of the rejection of the offer, right? So you're basically lots of things to figure out. But what about this contingency fee cases?
You can no longer enter a contingency. Well, I don't know if it was ever necessarily allowed in the rules, but you can't enter a contingency fee agreement as evidence of your attorney's fees. So anyone who's doing contingency must either keep track of their hours and, I guess, create whatever hourly rate they feel is reasonable, or I guess create the billable hours of their own, which I've seen the latter done quite a bit in appellate cases. But that contingency fee agreement can no longer be entered as evidence of attorney's fees. It's now codified. So one can't say upon receiving a nice $1 million judgment, say that I'm now entitled to attorney's fees. How much? Well, here's my contingency fee agreement, so $400,000. Or I guess my 25% lawyer would be $250,000. No longer allowed.
Yeah, that actually raises the question. If there's a billboard out there that says 25%, it's very hard, or 20%. I think it's 20%, maybe 25. But how do you convince the jury that I'm 40%, but the guy on the billboard's only 25% or 20%? But that used to be a favorite thing. If you hit the jackpot in your verdict, to be able to say, and especially under 91168, I guess, this is how much I should get in attorney's fees, which is 40% of the amount you just gave the client for their verdict.
And that section you're talking about now is not retroactive, right?
That's correct. That is not, that one's not, I guess, yeah, there are only two that are retroactive, and I'll point them out when we get there, but everything we're saying so far applies to all cases that are ongoing or have yet to commence, or causes of action that have happened in the past or are soon to happen.
So if the plaintiff doesn't make an election and take cases we have, Nils, where they've made all kinds of demands and 13611, numerous multiple 91168s, if they don't elect, is it the one that's made most recently, or are they out of luck if they didn't
Under
elect?
numerous 91168s?
I would say, I mean, personally, I would argue that it's the most recent in time, but of course, as a plaintiff, I would argue it's the earliest in time, and that would essentially be at the court's discretion by the wording of the statute, simply because it's silent to the issue. And I guess one other thing, the way that I read this theoretically is, let's say discovery disputes arise, and you request attorney's fees because you needed to move to compel responses, move to compel a witness to appear for deposition, and the court surprisingly grants you fees for that. So presumably that is included in all things encompassing attorney's fees, where you must designate one statute. So the way I read this is that you may still pursue under a different statute attorney's fees, but those pieces that which you have already received are no longer available. You can no longer, I guess, have your piece of cake and eat the rest of the cake too.
My general belief anyway was that you would have to subtract out what you've already been paid back from your claim of attorney's fees. That only makes sense to me, that if you get a big discovery sanction and recover 100,000 of your $1 million of fees, that you ought to subtract that from your presentation at trial anyway.
But having said that, that's kind of what happened in the junior case where they got both 9/11/68 and I forget what the first statute was, where they double recovered.
So one thing to point out is your contractual right to attorney's fees can still exist, and expensive litigation would still exist. So you don't lose that contractual right by reason of this statute. But let's see. What I'm trying to do is determine by looking when this election has to be made.
It pretty much just says in any civil action, a party must. That's pretty much all it says.
Okay, you got to do it sometime. Presumably before you collect. I don't know if you get to, I'm not sure if you get to get all the way to the end and then decide what you want to do or not.
Theoretically, I guess that would just be in pre-trial motions.
Because the bugaboo would be, you have no idea whether you're going to win 9/11/68. So you put on 13/6/11, and then if you do really well, it doesn't matter. But if you don't, then the court's going to say, well, you've already waived your 9/11/68 potentially. Okay.
Well, I guess attorney's fees is a good segue into the bifurcation.
Yes. So now we get into trial procedure, and I'm going to argue it's trifurcation that's now required and not bifurcation.
And I would argue it may be, as we just got recently a case, quadrification, which I didn't even know was a word.
I don't think it is.
That actually goes back to the old days of quadrophenia and quadraphonic stereo. Where we do have to have 4 speakers that will independently act to provide the music to you.
But, in any case, the new rule allows for a demand to be made at trial by either party. Presumably, this would typically be the defendant to conduct the trial in phases. And first and foremost, this one only applies to causes of action for recovering bodily injury or wrongful death. So it's this one's more tort specific, not necessarily all lawsuits encompassing, but the demand would be for the trial to be conducted in 3 phases, hence the trifurcation, where liability must first be argued, liability and apportionment of fault, with damages and dollar signs not being allowed into the evidence. It's a little bit loose as to what exactly can be argued with regards to phase 1, but the whole point is phase 1 is meant to be specific to liability and to apportionment of fault. Now,
doesn't that give the opportunity for each party to make an interim final closing argument?
well, the fact of the matter is you have a closing argument that is limited to that evidence that you presented as to liability or apportionment of fault. Then what would happen is, assuming that the jury comes back with a verdict awarding fault in the favor that would warrant damages, that same jury and that same judge are then to conduct a second phase of the trial that specifically addresses the amount of the damages, as well as, I presume, by the
Yes.
looks of it.
And this does say, the statute itself actually says same jury, same judge. So I don't think you can have a situation you're not supposed to where all of a sudden the magistrate judge comes in to try the second phase of the trial or something like that.
And then the third phase would be assuming that the damages are awarded. The jury comes back with a verdict awarding X dollars. The jury, same judge, jury would then be tasked with determining whether or not there is any entitlement to attorney's fees and or punitive damages and how much. So assuming this is a disputed fault case, as long as you make that demand, you're effectively cutting that trial into 3 pieces, all keeping that same jury and judge hostage in the same.
So what if there's no demand by the defendant or somebody else for a bifurcated trial or a quadrification?
Then it would just proceed as tort trials have been going, as we've done, where they argue both fault as well as presenting medical records and bills and damages, which is advantageous typically to a plaintiff, because when trying to determine fault and when you can also demonstrate really, really exorbitant medical expenses, it's inevitable to invoke sympathy. It's inevitable to make a jury maybe sway their decision on the fault just because they feel like the plaintiff is entitled to something.
But so if the defendant makes a demand for a trifurcation, what can the plaintiff do?
The plaintiff can move in opposition of it, which it's at the.
Which is not an objection, right? It's
Right.
actually a motion,
Yeah,
right? Which is a little weird.
where is it? The court may reject an election by any party made pursuant, where is it? Upon motion by any party. So presumably the party that didn't demand this trifurcation would then move to not have it trifurcated. And then only two instances in which the court shall grant that motion and keep it as a regular altogether trial. Phase one would be, or situation one would be a sexual offense in which the victim, the plaintiff, etc., would be under emotional duress by having to testify more than once about what happened. And then the second one, which opens up at least 3 can of worms off the top of my head, if the amount in controversy is less than $150,000. This is not like the federal rule where it's actually a floor of 75,000 where sky's the limit, so to speak. It's a ceiling. So what on earth does that mean? Does that include punitives? Does that include attorney's fees? What does that mean if the amount in controversy is, say, $90,000 in medical records? The plaintiff makes such motion on that basis and then gets the trial altogether and then proceeds to ask the jury for $2 million. And then say the jury awards $2 million. How does that work in practice? How does that requirement that the amount in controversy be less than $150,000 as a basis for the court to deny this trifurcation? How does that work in practice? It's silent as to such.
I think we could probably take a vote on whether amount in controversy includes attorney's fees, for instance. It would seem to me that it does. Unless there's some precedent out there. And anybody else got input on whether if you have 100,000, let's say you have $100,000 of attorney's fees, but you're pursuing a $10,000 case.
I would say it would not include, I would think they define amount of controversy as not including attorney's fees. Unless that's part of the underlying claim.
Is there any
That wouldn't be
definition of
the
that?
case.
No. Amount in controversy in this like rewriting of the statute is not defined. That's one of the issues.
So in the current state though, as the plaintiff, if you move to not trifurcate,
On that basis,
you might get nailed by, and you end up with
149.
$100 million verdict. They might get reduced to 150,000. I guess. I don't know exactly.
I don't either. I mean, personally, if I was in that situation and I had my trifurcation rejected on that basis and got a verdict of in excess of $150,000, I would call that to the court's attention, likely call for a mistrial and plan to appeal. That's just off the top of my head, based on the wording of that rule.
So that's a who thinks that's a significant, this trifurcation is a significant issue in the outcome of cases? I think it is too. The other thing with respect to the trifurcation is I call it the exemption motion. He calls it the opposition to trifurcation. We could call it a reunification motion, but there's a second aspect to this trial procedure that's important, which is the ability to argue a number in support of non-economic damages. And there's a long definition in the statute of non-economic damages, but it's essentially what you would think it would be. It would be basically pain and suffering, anxiety, discomfort, hardship, distress, suffering, inconvenience, physical impairment, mental anguish, disfigurement, loss of enjoyment of life, loss of services, loss of consortium, etc. Has anybody ever had a trial where the either you as the plaintiff's lawyer or where the plaintiff's lawyer, if you're defending, puts a number on what the jury ought to grant for non-economic damages?
I raise my hand only as a defense.
Okay. And is it typically a small number?
Well, I mean, we had one recently, I thought was kind of creative, where the plaintiff used a per diem, which I understand is no longer allowed. I don't know if it's expressly.
Not in the reform.
It's not expressly, and they used what our driver made per hour and per week, and used that.
We actually reduced that. He said their cheapest employee is what this driver makes. So we're going to take $2 off of that hourly rate and then multiply that by a full work week times years of her life to the end of her life.
That's pretty large claim.
Non-academic damage.
Right. And that landed them at a demand of $5 million for the jury.
Okay, and that was not subject to this tort reform act. But if it had been, when would they have had to argue that?
They would have had to argue that after the close of evidence.
Okay, so that means the way we're interpreting this, at least I am, is if you can't mention non-economic amounts of non-economic damages until after the close of the evidence, that means you can't put it in the
Record.
opening statement,
Oh,
right?
that either, no.
Okay. And then the way they describe this is it says if the party involved has both opening and closing arguments, which we must interpret as being
That's how it's written.
the closing arguments, either by way of and let's think about the various ways. For instance, a plaintiff could have both opening and closing. How would that come about?
Well, anytime defendant puts up evidence.
Okay. So, or if there's a counterclaim also, I guess. So if the defendant does put up evidence, and let's just, while we're on it, even though you just took a bite, if the defendant doesn't put up evidence, then it's switched, right? The defendant gets the final word, correct? The
Right.
plaintiff has to argue and the defendant has the final word. But if the defendant puts up evidence because the plaintiff has the burden of proof, then the plaintiff gets to argue, and then the defendant argues, and then the plaintiff argues again, right?
Right.
But what has to happen, Nils, in the first argument of the plaintiff if they're gonna present any number associated with pain and suffering?
They have to specifically state that number, and they cannot deviate from that come time for closing. So
Okay.
they're not only can they not bring it up in their final, I'm gonna start that over. If they don't bring up a number in their opening, then they are precluded from bringing up a number in their closing. In order to bring a number up in the closing, they must use that same exact number twice in opening and closing. So effectively, if the defendant or the plaintiff was to have the first say in the closing argument and the last say, this hypothetical plaintiff must then say $5 million before the defendant has any say in the matter, at which time the defendant then make their closing statement, and then they must come back and may again use the $5 million number, not 6, not 8, not 3, 5.
So what does this prevent? This prevents the defendant's attorney from getting sandbagged, I guess, by not arguing against the huge number
Or the basis of
first timer.
or the basis that they use to get there. Because, with this per diem thing, for instance, that can be undermined in closing, and it would be really beneficial to have seen that before we made our closing statement in that trial that Mr. Newsom was referring to.
Okay, so one more aspect of trial procedure that has come up in personal injury cases. What is it? Bodily harm and wrongful death?
Not sure what.
Referring to the medical.
Oh, boy, that's
So there,
the first of the two non-retroactive
Yeah.
ones.
so who has ever been to a doctor and the bill was $5,000, but you ended up only paying $150?
Well, I'd like that.
Well, what is allowed now with respect to evidence of actual out-of-pocket medical bills?
So in addition to the actual medical bills being presented as evidence, again, this is the first of the two that is not retroactive, only applies to all not just lawsuits, causes of action that arise after this act. But nonetheless, evidence of both the medical bills themselves and what the provider accepted, the payments that the provider accepted for said treatment. So you can't necessarily say that the provider, chose one or the other, but something that you previously could not do because it was it was teetering too close to the collateral source rule is that you may now show the jury $500,000 of medical bills. The doctor accepted $40,000. Ladies and gentlemen of the jury, that is up to you to decide. But that used to be too close to the collateral source rule, which is still in place. So you can't talk about where this $40,000 that was accepted for the treatment came from, but you can show that it was accepted in exchange for the treatment, and the books were closed by the doctor.
Yeah, and I call this the lazy trial judge rule, because I don't think collateral sources ever precluded a defendant from introducing not who paid, that's collateral source, a third party payor, but what was accepted because, and I've been wholly unsuccessful in this, because what that doctor accepts, they're not pro bono, they're not, unless it's indigent care, They're not pro bono, they're for profit. What that doctor or medical provider accepts for that medical service has to be indicia of the reasonable value of that service.
And that's,
I don't even know how, and I've never, when I've asked trial judges that directly, they default to, well, it implicates collateral source rule. They'll never answer the question because there is no. But this at least makes it clear. But I would argue, even since that's not retroactive, that's still, you should be able to introduce simply the amount that they accepted as an indicia of the reasonable value.
and the thing is, the reasonable value, that used to only, it wasn't necessarily codified per se. It was included in certainly appellate court decisions, and it's in the pattern jury charge for a reasonable value. But now it's included, the phrasing reasonable value is included in this statute. Not to mention, they address the collateral source rule. It says, and I quote, it is the intent of the General Assembly that this code section abrogates the common law collateral source rule to the extent necessary to introduce the evidence described in this section.
Okay, so apparently, have you been down there lobbying? Yeah.
Nobody listens to me at home or here.
But there's other aspects to this same portion of the statute, which is referring to 5112 1.1. And that is that if there is a letter of protection, which is apparently a letter that tell me if I'm wrong, a doctor will write saying, if you come treat with me, I will not charge you, but I'll only collect when you ultimately win your lawsuit or collect on the settlement of a lawsuit.
Except they also go on to say, but the entirety of the bill is your responsibility as the patient. That's what they also add to those letters of protection to keep them out of evidence, at least historically.
Okay, well, what they say here is that these letters of protection shall be relevant and discoverable. And does that mean that it can be admitted into evidence?
It says relevant. I mean,
Yeah, if it's relevant, you would think it'd be admissible into evidence. So if you go to if you have a car wreck and you go to and tell the Arrowhead Clinic that I had a car wreck and I need chiropractic help. I'm just drawing back on my many, many years in Atlanta. And they enter into a letter of protection with you and they do all this treatment to you. And that apparently now is admissible into evidence, presumably by the defendant, as to the reasonable value of the health care and how it came about, et cetera.
Well, and it's to bias.
And then also if that provider sells those accounts receivable to somebody else for a lesser money than the face value, then that also is admissible, I believe. So to me, this is going to turn over or upset a lot of the general plans of the plaintiff's bar because it's going to make things more transparent, but also more problematic.
And Henry, just to show how bad it really was, the case Nils and I recently tried and some others where we've taken expert medical provider depositions, the surgeons will plead absolute ignorance as to the cost of the procedure. They could be and there's some case law, but there's no consensus. But we had recently an owner of the medical practice who had performed these same surgeries for 10 years, who disavowed any knowledge as what they cost. That's for the front office. And so what you then have is the plaintiff, who is by statute entitled to authenticate his or her medical records without anything further, says, yes, these are my records. And you have no evidence as to reasonableness or necessity of those medical expenses, but it's going to the jury. And you as a defendant, essentially, by virtue of this quirk, you've allowed the doctor to just stay clear of it as if he or she has no idea what the value of that.
And you ask the
surgery is.
doctor, how much money do you have to make per day to get yourself out of bed and go to work? Or how much money do you take home at the end of the month?
We will be able to answer that for you in September because we've asked a lot of those questions and we'll see what the Well, the judge will tell us in June
Right.
how much of that we're gonna be able to get in front of a jury.
Also, in that particular instance, the expert testified that he had been practicing for, I want to say it was 8+ years, and was under the assumption that the prices were established by his people, his financial group, and they had not changed in the last 8 years, which frankly, anyone who's been into the grocery store multiple times in the last 8 years knows is absurd.
And claimed it was, his lawyer, he had his personal lawyer there, claimed it was proprietary trade secret information, what they charge,
I see.
which I found to be absurd, but that's what they said.
Is this a expert witness or is this just the treating physician?
Well,
Both.
yeah,
Established
really
initially.
both. Somebody tied to the plaintiff's firm.
Okay, so that again will affect personal injury and wrongful death cases.
And I guess another protection that is the only other of the two that is not retroactive, so only applying to causes of action arising subsequent to this act. And also encompasses about half of the pages of this Tort Reform Act is negligent security. And by negligent security, I mean a brand new cause of action that has finally been codified, even though that phrasing has probably been used in complaints for the last several decades, if not more. Typically, if somebody was to, I don't know, be outside of a McDonald's and be subject to a carjacking, McDonald's may be liable for negligent security. The theory and statutory basis upon which one typically makes that claim is under ordinary negligence with the theory of premises liability, which is a very broad term and very broad interpretation of the law. It's not broad anymore. Now there is in the tort title a negligent security cause of action that very narrowly and rigidly defines what negligent security is, and goes further to say that any kind of bodily injury or wrongful death recovery under this chain of facts must be limited to this negligent security. So that means you can't just say negligent security plus ordinary negligence under premises.
Okay, and they do divide this up depending on what sort of person it was that allegedly got hurt on the property. You have invitees, which include people within a certain distance, I believe, from the property.
Yeah, it includes adjoining property, the premises, the adjoining property, and property within 500 yards, I believe is the number.
And then you have licensees, who are people who just happen to come upon the property but are not trespassers.
Right, but that scope of negligent security is limited to the premises.
And then you have
Trespassers.
and felons. If you come on, do not try to bring a claim if you are a felon who comes onto the property and then gets beat up while you're on the property trying to commit a felony.
If the visitor is a trespasser, then the negligent security cause of action has a complete defense for it, as codified here.
Now, one thing they do point out is that allocation has to be made between and among all the potential people at fault. And I'd have to find that section, but I believe if the fault allocated to the, here we go, 51-356, if the fault allocated to the wrongdoer is greater than the fault allocated to everybody, is not greater than the fault allocated to everybody else, then there is either a mistrial or a grounds for a new trial. Let's see, if the jury fails as a trier of fact to apportion a reasonable degree of fault to the third person whose wrongful conduct was a cause of the injury from which the claim of negligent security arises, the trial court shall set aside the verdict of the jury and order a retrial of liability and damages. There shall be a rebuttable presumption that an apportionment of fault is unreasonable if the total percentage of fault apportioned to all third parties from their wrongful conduct is less than the total percentage of the fault apportioned to all owners or occupiers, security contractors, and other persons and entities that do not engage in the wrongful conduct. So this eliminates the situation where the person commits a murder on somebody else's property and the jury was, well, the murderer is not going to have any money, so we'll make the hotel owner liable.
Right, and not to mention this this also dramatically, bringing apportionment of fault into this cause of action does dramatically change it. Well, hypothetically speaking, I mean, there have been a number of cases that I've litigated that were involved disputes in nightclub properties where somebody was drunkenly angry at somebody else and then they started a fight in the parking lot, which was still constituted the premises and would fall under this statute should that have arisen after this act. So if hypothetically me, Mr. Boyle, Mr. Newsom, and Mr. Virgin were to start a fight club in the parking lot outside the Battery, and then one of us got hurt and then tried to sue, not only would we be guilty of breaking the first two rules, but it wouldn't entirely be our fault. And so there would be an apportionment issue that would likely negate liability.
So, one of the things that there's a very strict and rigorous requirements of the plaintiff to show how much knowledge the defendant had, the principal defendant had of the likelihood that this third person wrongdoer would actually do something bad on their property. And also the type of bad that they would do. For instance, I suppose if you had somebody who lived near the property who was known for, shooting spitballs at people that were coming into the parking lot, then that wouldn't necessarily in any way give you knowledge that the person would also strangle people and rape them. But there's a heavy requirement of showing of what the property owner or occupier would actually know about the wrongful actor. And if they can't show that, then they're out of luck, I think.
And under the definition, what the knowledge that the owner or occupier of the premises must have, it states such information being specific as to the identity of the third person, the nature and character of the wrongful conduct, the degree of dangerousness of the wrongful conduct, and the location, time, and circumstances. So it's a suddenly much bigger burden to pass.
So I will not be starting my premises liability personal injury plaintiff's firm today. I don't think.
Unless, of course, you were to advertise that I can represent you for anything that happened before this date.
Now they're because of the.
It's not retroactive. That's one of the other two that's not, or one of the two that's not retroactive.
Okay. So there is one other portion of this which relates to car driving and riding. What is that?
Well, it's appropriate that we only have a few minutes left because that one's pretty minuscule. It was previously inadmissible for it to be admitted into evidence that a plaintiff was not wearing their seatbelt, or I guess wearing their seatbelt for that matter, when it came to the car accident injury lawsuit that in which the plaintiff alleged injuries. It is now admissible. So if you find out, determine, they might lie at deposition, but if you can find via Axon footage, body cam footage, or dash cam footage, or what have you, that evidence that the plaintiff was in fact not wearing their seatbelt, you can bring that into evidence to undermine their injuries, presumably.
Yeah, so to the extent you're defending car wreck cases, that you can now get that discovery and put it into evidence. I presume you could get the discovery before, but just not enter it into evidence.
Well, you could discover it before, but not enter it. But that in practice, I mean, that just occurred to me that most of these cars are electronic and, have sensors for their seatbelt. Presumably, if you hire an expert to take apart the computer of the car and download all of the data, it would actually include whether or not a seatbelt was active at the time of the accident. And that can be used to absolutely undermine the severity of the injuries, even if you can't necessarily argue fault.
So it only goes to the issue of severity of the damages and not whether there's fault?
You're implying that there's probably more, so I'll defer to the longer practicing attorney, but
Well, I don't know.
that's my first. That's the first way I see it being used, because if you get rear-ended per se, it's presumably the other driver's fault unless you slammed on the brakes and hit reverse to try to show them who's boss. But the fact of the matter is, if you're not wearing your seatbelt, it's presumed that your injuries may have been less severe had you been basically following the laws of the road.
Okay, any questions or follow-up? There's been a lot. Anybody online? Don has one.
On the motion to dismiss, I mean, I can't remember. Well, anyway, the statute was amended some years ago, now 11/12, with the discovery stay.
Right.
And the question that I've seen come up in several cases is, does that apply to a partial motion to dismiss? And I see the new statute still doesn't explicitly address that.
It does not.
I find judges generally do apply it to partial, have applied the stay or partial motion to dismiss.
Right, so the partial motion to dismiss though is for a maximum of 90 days, right?
Yeah,
So that means at least there's a deadline on it. Whereas I would think now that, I think it probably does apply to partial motions to dismiss.
I mean, the way I've argued, I mean, I've never had a judge push back on it, but the way I've put aside in a brief, like, if you're in federal court, well, federal court used to be different from Georgia, and that you could file a motion to dismiss in lieu of an answer. And the question there is, does a partial motion to dismiss relieve you of the obligation to file an answer? And so, using that case law by analogy, I said, well, since the general rule in federal court is, it does relieve you of filing an answer, maybe you ought to give a stay in state court. But I mean, I guess that raises the question, under the new act, are you relieved of filing an answer if you want to have a partial motion to dismiss?
Well, it sounds to me, that since the new rule is bringing the Georgia state laws more into line with the federal rules, it sounds like that would kind of presumptively follow, because they would probably defer to filling in any holes in these rules with the federal rule upon which it was based.
Yeah.
So while we're talking about that segment, which is 9/11/12, I will say there's edits to the Rule 12E relating to motions for more definite statements.
So, yeah.
And it has timelines associated with notice of an order, not notice of an action, but notice of an order by the court regarding the granting of the motion for a more definite statement, which requires the plaintiff to file
15
within
days.
15 days of notice of the order, file a more definite statement.
And again, as we mentioned before, presumably on the safe side, and probably in theory, that notice would be if you had a hearing and the judge said, I'm going to rule as such, boom, 15 days starts.
So that pretty much wraps up our overview. Hope it's been fun. Hope that we don't have too many headaches coming out of this, but knowledge is powers. Thank you for participating and increasing our knowledge.
Thank you. Paragraph. Well done.
Thank you.
I think we should